we are targeting gang members who decided to wreak havoc on communities in Fulton County. And the ironic part of the community that they violated were those communities were communities of color. See, no one rarely talks about the victims in this case. But the victims in this case...
All right. I'm sorry, y'all, to interrupt. But already with the BS...
Stop the cap.
Victims?
What?
Victims?
What?
Can y'all tell me in the comments and in the chat how many murder charges were dropped during this trial? And we want to talk about victims.
What?
Please don't do that, Miss Hylton. Please don't do that. How many was it? 4? 5? 6?
Most of them are people of color. Because in Fulton County, you don't get to victimize anyone in our county without being held accountable for your actions. And what we're going to ask of you today is hold both of these defendants accountable for their actions. Because they are guilty of every single crime for which they are charged. But as both Mr. Shard and Mr. Wanzi were talking, I was reminded that what is right is often forgotten or is convenient. And see, in this case for them, it's convenient to blame Kenneth Copeland for the murder of Donovan Thomas. Well, we're going to talk about that. That doesn't even make sense. For them, it is convenient to tell you that we have not met the elements of RICO because they're just not a gang. They just get YSL tatted on them. They just get snakes tatted on them just for the fun of it.
What is she doing?
That's convenient for them. But that's not the truth. And while it may have taken some time for us to get all that evidence out here, it took a while. Some days the evidence came out good. Some days the evidence came out bad. Some days I had to take a couple of breaks. At the end of the day, the evidence shows what is clear. YSL is a gang. YSL is an enterprise. They commit criminal street gang activity. They murdered Donovan Thomas, murdered Chanel Drinks, and they're guilty. And then I'm also reminded of a story that a colleague told me a long time ago about someone who worked as a Border Patrol officer. And this person worked as a Border Patrol officer for a number of years. And while they were working Border Patrol, a guy would come through the border with a red bike every day. And every day that that person would come through with a red bike, he had a basket on the front of the bike. And inside of the basket was some food. Now, every day, this guy would come through, and the Border Patrol officer thought something was kind of fishy, but he never found anything. He always found baskets with sand inside of it. This happened for a few months. Well, one day, the Border Patrol guy was leaving that job. He was going to a new job, and he was at a bar. And who walks into the bar? The guy with the red bike. So the Border Patrol guy says to him, I'm getting ready to leave my job, but I'm interested. There's something was fishy about that red bike. What were you doing with that red bike? And the guy was like, nothing, don't worry about it. Congratulations to you. The night proceeded. The Border Patrol guy got some more drinks in his system and said, you know what? Can you tell me about this red bike? Because something just doesn't seem right. Every time I would see the red bike, it would have sand in the basket. Tell me what was going on. Guy said, don't worry about it. Finally, it's the end of the night. Border Patrol guy is really intoxicated. He said, just tell me. I'm not going to remember what happened. You're not going to get in trouble. Tell me what you were doing. And what the guy said was, you know how every day you were focused on the basket with the sand? I was smuggling in a new red bike every single day. So you were so focused on what was in the basket that you was missing what was right in front of you. And if you listen to what the defense counsel told you for the last about 3.5 hours that they argued, you're going to miss what's right in front of you. So what's sand in the basket in this case? First things first, stolen jewelry. APD, somebody stole this watch.
I'm going to let her cook.
No one stole the watch. The watch is left back in the house. But they want you to focus on this watch because if you focus on the watch, you're going to miss the evidence in front of you. Talked about no reports. You know, Viverito, she didn't write any reports. Well, what she told you is she wrote her information in the affidavits. affidavits that get sworn before a judge. Probably better than reports because a judge has to actually read that information. But if you focus on the fact that they're reading and writing reports, you're going to miss what's right in front of you. Mr. Weinstein talked about length of time. We talked about that. Knowledge of co-conspirators. I think at one point in time, Mr. Shard said, Mr. Minor, who stabbed Lucci, he doesn't know Mr. Kendrick or Mr. Stillwell? Maybe not. But he knows Khalif Adams, who's the one who helped set up stabbing Lucci. Khalif Adams knows those two. Well, knows Mr. Stillwell. Khalif Adams knows Garlington. And so, some way, somehow, though, Mr. Stillwell knew on February 9th that Lucci got stabbed. Well, how does he know that? How is that in a text message? That wasn't broadcast to the world. So this idea that just because Mr. Myrick doesn't know him specifically does not mean that they're not guilty of the crime of which they committed. They talk about witness credibility, specifically about experts and what our experts said. But if you go back to any of our experts' testimony, Belknap, Dennis, Gaither, Underwood, the things that they talked about, there were examples of it. They talked about YSL was a hybrid gang. It was Bloods and Crips, and they kind of got together. Well, we know that's true because Martinez Arnold is a Crip. Some of them, Mr. Williams was a Blood. You saw when he talked about sex, money, murder. You see them hanging out together. You see them committing crimes together. Mr. Kendrick and Mr. Arnold in a car with guns on their way to Trestle Street. We can infer, go shoot it up. That's what they talked about when it says a hybrid gang. They talked about the music, and we're going to get to the music in a minute. They talked about the fact that gang members use their music in order to brag, promote what they've done in the gang. And we'll see examples of that in a moment. We talked about your duty earlier today, but again, just to be reminded, you're supposed to be a fair and impartial juror, honestly seeking the truth. You are not to seek doubt. So when you go in the back, you're supposed to say to yourself, what happened on January 10th? What is the truth about that? And is there evidence towards the truth? That is what you're here for. Seek the truth, you follow the law, and you deliberate. Now, I want to tell you this. If you go to the back to deliberate, and one of your numbers says, I'm not deliberating, I'm going into the bathroom, I'm not doing any of this, you need to bring that to the deputy's attention so they can bring it to the court's attention. Because you have a duty to deliberate. A duty to sit down, evaluate the facts, evaluate the evidence, and apply it to the law.
Oh, she's asking them to snitch? Oh my. Y'all think that was directed at juror 56? He said, my mind's already made up. I ain't think. That was wild that she said that. She told them to snitch. That's insane. Oh my gosh. 56, hey, she said you're gonna sit your ass.
So earlier this morning, Mr. Adkins talked to you about count 57, participation in criminal street gang activity. He talked to you about count 1, conspiracy to violate the RICO Act, and counts 50 and 51. I'm not going to harp on that again, but I thought it interesting when Mr. Weinstein said, well, we haven't proved count 50 and 51 and 57. You know, the state, they're all dressed in red. We are. Red's probably my favorite color. But you know the one thing that's different? We don't do criminal gang activity. And the court's going to define what that is. See, we're not here because people wear the same colors. They can wear all the greens they want. They can wear all the snakes they want. If they all want to tattoo YSL on them, that's fine. We told it's not a crime to be a part of a gang. The crime is when you start doing criminal street gang activity, like murdering Donovan Thomas, murdering Chanel Drinks, murdering Jamari Holmes. That is
prosecutorial misconduct a crime?
Not being a member of a gang.
Technically not, I guess.
So you'll see, and we said it again, that on the left-hand side were the charges for Mr. Kendrick, on the right-hand side were the charges for Mr. Stillwell, and in the middle is what they were both charged with. So Mr. Kendrick is charged with possession of marijuana with intent to distribute. That's from May 9, 2022, when he was found running from Mr. Williams' house. Remember, the officer came and said that they both must have been out of breath and he ran from the house. And the drugs and the guns that were found inside the house. The marijuana and the guns that were found in the house. So in order to prove this, we have to show that the defendant possessed with the intent to distribute any amount of marijuana. Marijuana includes all parts of the plant, What it does not include is the hemp products and all those other technical terms that I'm not going to try to pronounce for you tonight. We have to show that he possessed it, and it has possessed the marijuana or the firearm. We're going to talk about the firearm in a moment. Possession must be actual, constructive, sold, or joint. So we're going to tell you that it's not actual possession. No one caught him with the marijuana in the hand. We're going to talk about constructive possession. At the time of the alleged offense, he did not have direct physical control over the marijuana or firearm, but did knowingly have both the ability and the intention to exercise control over the marijuana.
So he was in the
room.
room.
He doesn't have sole possession or focus on joint possession. Defendant share possession of marijuana or firearms with at least one other person. What evidence do we have of it? And I know Mr. Wine said we didn't have any evidence. We do. Pictures are evidence. That's direct evidence like we talked about earlier. This is inside of the home of Mr. Williams.
Ooh, that's a nice house.
That's the money counter that was sitting next to the Tupperware bowl full with the marijuana.
Not a crime.
That's the Tupperware bowl full with the marijuana. That's the more marijuana that was in that cabinet in that same kitchen right across from where the Tupperware bowl of the marijuana was. And those are the two guns that were found inside that area. Now, ladies and gentlemen, you heard the testimony that SWAT, when they came, did not immediately make entry into the house. It was like announced, it was loud. So I submit to you that they had the opportunity to put stuff away, to hide stuff, because they didn't just come in immediately, ladies and gentlemen.
Here's the I believe again. Dang, I did not. I wanted to let her cook, but this is such BS.
Right, and so what we have ultimately is that there is no evidence, none.
So can we go back to her definition? By her definition, was he... How is this constructed possession? I'm gonna let her cook. Was he there? Was he around the weed?
So you can take that into consideration as you deliberate.
Oh my God.
Possession of a firearm during the commission of a felony. So the state must prove that the defendant had a firearm on his person or within arm's reach while committing a crime against or involving another person. For Mr. Stillwell, it's murder. For Mr. Kendrick, is the possession of marijuana with intent to distribute. So how do we show this? On the left is Shannon Stillwell. That is Mr. Drinks inside of the vehicle.
Dang,
we know that Mr.
tough.
Drinks was shot with a 40 caliber gun, possibly of a Glock, and we're going to talk about this Glock in a moment. So you can infer, although we do not have the gun, that Mr. Stillwell possessed the gun that shot and killed Mr. Drinks because he's dead and because we have the bullet. You can infer that that's circumstantial evidence. Your direct evidence is someone is deceased. You have bullets. We know those bullets come from a Glock firearm. So the only way you can infer that the shooter, Mr. Stillwell, possessed a firearm. Mr. Kendrick, again, he had firearms inside of the house at the time when the house was raided. There were two found inside of that cabinet. There was the one that's found on this counter.
Is that his house? What are we doing?
Now, they're also both charged with possession of a firearm by convicted felon. You have to show for Mr. Stillwell, he has 2 counts. And interestingly enough, I was listening, Mr. Shard never talked about count 64. But we're going to talk about count 64. But count 52 is that he's a convicted felon and he had a firearm when he murdered Chanel Drinks. And in count 64, which is when he was apprehended, the gun that was found in the middle of the road, that we charged him with that weapon as well. And then again with Mr. Kendrick, that there were guns and drugs at Allison Drive on May 9th.
I mean, is it possible it was a throwaway? And I mean, she's still basing all of this on the fact that they believe that he killed Shannon Stillwell, which we all know and the jury knows that man did not shoot Shamel Drinks. I said Shannon Stillwell. Shamel Drinks. What are we doing?
And let me also say that in the indictment, possession of a firearm by convicted felon is going to be a lesser included of what is charged. What is charged is a different charge, but possession of a firearm by convicted felon is a lesser charge, and the court is going to instruct you, and you can find both of them guilty so long as you believe that both of them possess a firearm and they have been previously convicted of a felony.
How? Where?
What do you have in evidence? You have State's Exhibit 60G and State's Exhibit 30Q. Both of those are the indictments of Mr. Stillwell, which he was charged with and convicted of a felony. So that is the felony that we're saying he should not have been in violation of. or he should not have possessed the firearm.
Yeah, we don't care about that. Where's
As
the
I
firearm?
discussed, because he's a convicted felon, he should have never had a firearm when he murdered Chanel Drinks. For count 64, what do we have? Remember, this is on March 17th, after they fled from the Chick-fil-A. And remember, Trooper Campbell came in and said that he found the gun in the middle of the road. You saw the dash cam video when he kind of turned around and found this gun. Then we brought in Mr. Stillwell's former girlfriend at the time, Taisha Alexander. She said that she aborted the gun. That was her gun. That gun came back to Ms. Alexander when we were able to compare the serial numbers on both the gun that was collected and the receipt from Arrowhead Pond. And further, we played these wiretap calls for you.
Hello? Yeah. I don't know. China called like really played on a high-speed chase to the Lava House.
Yeah.
Why can't he in a high-speed chase if he in a rental legit?
Yeah.
He got my legit gun.
So the fact that she says he got my legit gun, which is that gun right here, he should never have ever even been in possession of it.
Thank
I don't
you.
know what it is. I don't know what's going on.
I don't know what's going on either, because usually they'll call like how he got my gun.
Thank you, Amy.
Yeah.
They'll call me like, come get your gun, but they ain't even called me. So I don't know if where my gun is, I don't know what's going on.
And again, this phone call was done on March 17th, the day he got arrested. The day Mr. Stillwell, got arrested.
All right. Well,
Now for Mr. Kendrick,
we'll let her have
we
that
have
one.
in evidence State Exhibit 487 BV, which is a certified copy of conviction of Mr. Kendrick. And again, because
it's reasonable doubt, right? So I get what y'all are saying. Jeezy says can't convict someone of a gun charge when you didn't catch them with the gun and no proof of the murder. Well, the gun charge is probably going to be a tough one. He's probably going to get that possession of a firearm just because reasonable. Is it reasonable to think that his girlfriend's gun just magically appeared out of thin air somewhere near where he got arrested? I mean, come on. So they're probably going to get him on that one.
because he's a convicted felon, he
They'll
should
probably
not
get him
have
on 64.
been in constructive possession of any of these guns that are inside the home. So now, based upon what we have shown you, they are guilty of, right now, count 1, count 50, 51, 52, 54, 57, 58, 61, 63, and 64. So let's spend some time on the murders, because that is what we need to talk about.
They're going to get Shannon on 64 for sure.
So for the murders, Mr. Stillwell is charged with count 2 and count 49, which is Donovan Thomas Jr. and Shamel Drinks. And Mr. Kendrick's charged solely with count 2, which is the death of Donovan Thomas Jr. You're going to hear the court read you an instruction about intent. Intent is every essential element of any crime must be proved by the state beyond a reasonable doubt. It may be shown in many ways, provided that you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it is the natural and necessary consequence of the act. Intent does not mean the intention to violate the law or to violate a criminal statute, but it means simply the intention to commit the act that is prohibited by the statute. So what are the elements that we have to prove for murder? That Mr. Stillwell and Mr. Kendrick caused the death of another person, here, Donovan Thomas and Chanel Drake, unlawfully and with malice aforethought. What is malice? It is not necessarily ill will or hatred, rather it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with deliberate intention to unlawfully take the life of another person, or where there does not appear to be significant provocation and all the circumstances show an abandoned and malignant heart. You often hear about premeditation. Some of you like watching these crime shows. The state does not have to prove premeditation to prove murder. So we don't have to sit and say you planned it out and you all mapped it out and that you knew you were going to kill Donovan Thomas or Shamel Drinks right at that moment. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. So when Diamante Kendrick rode by the barbershop and they saw Donovan Thomas sitting outside with his friends, and I'm going to submit to you, they started calling saying, yo, Donovan's out here. Let's go do this. That's enough. Or with Shamel Drinks, when Shannon and Garlington are sitting in the car, and they're backed in, and they see Mr. Drinks pull in, and they realize, oh snap, that's the dude from the Shell Cal post. And they see him walking up, and they decide at that moment they're going to get him because they're going to get revenge, they're going to get back. That's enough right there. Doesn't have to be days planned. Within moments, that is enough. No specific length of time is required for malice to arise in the defendant's mind. It may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act of the killing and moved the defendant to do it, that is enough for the killing to be murder. Now, motive. The law says we don't have to prove motive. You want to know why? Because oftentimes I can't get into the mind of why someone wants to murder somebody. But here, and we're going to talk about it, we have some evidence of motive. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. So you heard Mr. Agnes talk earlier about parties to a crime. I'm not going to go over all the principles again, but he gave you the example of the bank robbery, right? Everyone who is a part of the crime is responsible.
That's true.
So in this case, for Donovan Thomas, Mr. Kendrick, the driver. Mr. Kendrick, the state's belief, and the state's theory, is that he alerted them about where Donovan Thomas was. Because he was the one that was at the Texaco. He's the one that waited 40-something minutes for the Infinity to pull up. He's the one who got out of the Bonneville and went to the Infinity. He's just as guilty as the ones who pulled the trigger. Nard and Mr. Jackson. He's just as responsible. And that's what parties to a crime says. Every person involved in the murder is just as responsible as the person who pulls the trigger, because you all act together.
Thank you, Lane.
Now, we have in Chanel Drinks an individual that you kept hearing about, DeMarco Boyer. And someone brought up that DeMarco Boyer isn't on the indictment. Well, this is the law that's going to be instructed to you. Any party to a crime who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was committed and that that person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted,
It
has
was
been
just an
convicted of a different
analogy,
crime or
Brooklyn.
degree of crime, is not amenable to justice, or has been acquitted. Mr. Boyer's dates for another day. We're not going to talk about Mr. Boyer today. Today, we're going to talk about Mr. Stillwell and Mr. Kendrick. You can look at presence, companionship, and conduct before and after the commission of the alleged offense. And those things may be considered by you in determining whether or not the circumstances, if any, give rise to an inference or the existence of a conspiracy. So what does that mean? You can look at what they did before, what they did during, and what they did after. And for both of those murders, we're going to talk about conduct before, conduct during, and conduct after.